Hello, I'm David Rudoi, a criminal defense attorney based out of Bloomfield Hills Township in Oakland County, Michigan. One of my primary focuses is Michigan medical marijuana law. I'd like to preface this by letting you know that this is not legal advice, just my opinion based on my experience. Today, we're going to discuss the weight restrictions on medical marijuana patients and caregivers under the Michigan Medical Marijuana Act. Under MCL 333.26424A, a qualifying patient who has been issued and possesses a registry identification card shall not be subject to arrest, prosecution, or penalty in any manner or denied any right or privilege provided that the patient possesses an amount of marijuana that does not exceed 2.5 ounces of usable marijuana. So as a patient, the maximum that you would be allowed to possess is 2.5 ounces under the Michigan Medical Marijuana Act. If the qualifying patient has not appointed a primary caregiver to cultivate marijuana for the qualifying patient, then that patient may also possess up to 12 marijuana plants as long as they are kept in an enclosed and locked facility. Under MCL 333.26424B, a primary caregiver who has been issued and possesses a registry identification card shall not be subject to arrest, prosecution, or penalty in any manner or denied any right or privilege provided that the caregiver does not exceed 2.5 ounces of usable marijuana for each qualifying patient to whom he or she is connected through the department's registration process. If you're a caregiver and let's say you have 3 patients, the maximum amount you would be allowed to possess under the Michigan Medical Marijuana Act would be 7.5 ounces. A primary caregiver may possess up to 12 marijuana plants kept in an enclosed and locked facility for each registered qualifying patient who has specified that the primary caregiver will be allowed under state law to cultivate marijuana for the qualifying patient. So let's say you're a caregiver and you have 3 patients, plus you're a caregiver for yourself. You're a patient, but you've appointed yourself to grow. Then you would have a maximum of 48 plants that you'd be allowed to grow under the Michigan Medical Marijuana Act. 3 patients that you caregive for, plus you are your own patient. 48 altogether. These weight restrictions do not include any incidental amounts of seeds, stalks, and unusable roots. The weight restrictions are expressly stated in the Michigan Medical Marijuana Act, Section 4. However, there's a separate section, Section 8 of the Michigan Medical Marijuana Act, which sets forth an affirmative defense for registered qualifying patients and caregivers to assert in a criminal trial. This is just for use in a criminal trial. The burden will be on the defendant, but if the defendant can prove that he's in conformity with Section 8 of the Act, he will secure a not guilty from a jury. Section 8 of the Act states that the affirmative defense shall be valid if the patient and the patient's primary caregiver, if any, were collectively in possession of a quantity of marijuana that was not more than reasonably necessary to ensure the uninterrupted availability of marijuana for the purpose of treating or alleviating the patient's serious or debilitating medical condition, or symptoms of the patient's serious or debilitating medical condition. Section 8 says a reasonable amount term, but they don't define that term at all. In the Michigan Appeals Court decision of People v. Redden, the court questioned whether the reasonable amount term in Section 8 is the same as the 2.5 ounces which is provided for in Section 4. The court concluded that had the intent of this statute been to have the reasonable amount term equal the 2.5 ounces contained in Section 4, the drafters of the legislation would have inserted that into Section 8. Instead, Section 8 only contains the language of reasonable amount necessary to ensure uninterrupted availability. Thus, the court decided the affirmative defense contained in Section 8 requires evidence that the amount possessed by the defendant is the reasonable amount for the purpose of providing the patient with uninterrupted availability based on the patient's specific needs concerning their medical condition. They'll determine this on the case-by-case basis. In order to be sure you receive the maximum protection under the Michigan Medical Marijuana Act, it's likely that the best choice is to stay well under the 2.5 ounces per patient restriction from Section 4 and make sure the amount possessed is a reasonable amount in order to provide uninterrupted availability based on you or your patient's specific needs. For more specific questions, advice should be sought from an attorney. Thank you.